If you've got adult, responsible, mature kids, the question often comes up, should I pass my IRA to the trust that I've created for their benefit, or should I name them outright? And there's really no right answer to that. It really depends on what your preference for how those assets are received and held after you're gone would be. The difference would be if you name them individually and outright, then they will just own that asset in their own name after you pass away, and they'll be responsible for administering that asset according to the Secure Act's regulations in the appropriate way given their circumstances. If you transition or pass that asset through your trust, so naming the beneficiary designation to be the trust instead of your kids, then a few additional things are true. We still have to comply with the Secure Act regulations around how a beneficiary receives that benefit, the same way we would if they received it outright, except a trustee, who is generally going to be more financially responsible and competent, is going to be in charge of doing that instead. Additionally, any assets held in your trust after you pass away will be treated as if they're not owned by your child outright. And so they're not then susceptible to any spousal claims, creditor claims, or any reach by third parties. Additionally, your trust will control what happens to that asset if your child passes away. And so if your intention is for your assets to pass on a bloodline basis, instead of being passed to your daughter or son-in-law, a trust is a great way to force that to be the case, instead of potentially passing to unintended beneficiaries.